Washington, D.C. has some of the strongest tenant protections in the entire country, and habitability is no exception. If you own rental property in the district, you're operating in one of the most heavily regulated rental markets in the nation, so you need to know exactly what's required. D.C. habitability law is governed by the D.C. Housing Code, found in Title 14 of the D.C. Municipal Regulations, along with the Rental Housing Act and various provisions under D.C. Code Title 42. Together, these create a comprehensive web of obligations that landlords must follow. Under D.C. law, landlords are required to maintain rental units in a condition that meets all housing code standards. That means your property must have a sound structure, free from defects, adequate heating, capable of maintaining at least 68 degrees Fahrenheit from October through May, functioning plumbing with hot and cold running water, safe and up-to-code electrical systems, working smoke and carbon monoxide detectors, freedom from rodent and insect infestations, adequate natural light and ventilation, and properly maintained common areas. What makes D.C. stand out is the enforcement infrastructure. The Department of Buildings, formerly the Department of Consumer and Regulatory Affairs, actively inspects rental properties and can issue citations, fines, and even orders to vacate if conditions are severe. Tenants can request inspections at any time, and landlords who fail to comply with correction orders face escalating penalties. D.C. tenants also have powerful legal remedies. They can file complaints with the Office of the Tenant Advocate, a government office that exists specifically to assist renters. Tenants can pursue rent withholding, and D.C. courts have a well-established process for rent escrow where payments are held by the court until repairs are completed. In some cases, tenants can make repairs and deduct the cost directly from rent. D.C. also has one of the broadest anti-retaliation laws in the country. Landlords cannot take adverse action against a tenant for reporting code violations, contacting the tenant advocate, or exercising any legal right, and the burden of proof in retaliation cases often falls on the landlord. One more thing D.C. landlords should know. The district requires a housing business license for all rental properties, and maintaining that license is tied directly to housing code compliance. If your property fails inspection, your license can be revoked, which means you legally cannot collect rent. For a full guide to Washington, D.C. habitability requirements, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel to keep up with every jurisdiction in our series.